which was a townhome and it was in Central Florida, Orlando area. Wait, somebody just said something about him taking a plea. What are you talking about? Darrell Brooks would not take a plea. You're kidding me. Who said this? LaFord? Wait, what? Brooks may have taken a plea? No way. Where are you seeing this, Scissorman? I'm on the thing. I don't even see it. I'm on the docket. Hang on. Courtroom's not live. Let me double check the docket. Of course, they wouldn't have updated the docket that quick, I don't think. I see no updates. There's nothing on Twitter. Let me look at one more thing real quick. Y'all are freaking me out. I just can't see him taking a plea. Come on now. Really? That cannot happen. There's nothing. There's no updates that say that. Where are you getting this from? Let me go to VineLink real quick. Bear with me. I'm trying to look it up. Wisconsin. Search for someone. I always forget to look at this VineLink. Nothing. I got nothing here. Oh, the notification on this particular trial has been disabled. That's craziness. All right. Let me look back at the chat. Hang on. Y'all are chatting way too quick. I can't see anybody. Oh, people on the LNC chat said took a plea. Well, how do they know? There's a plea deal in 2020 for another crime. Okay, maybe that's what they read and thought it was current news. See, we can't be. This is what I'm saying. We got to vet this stuff. I hate fake news. And exactly, LaFord. He wants to face Erika. I just cannot see him doing that. And Naomi's right. There was nothing to gain on his nephew's case. It was like he wanted to get straight to Erika's stuff. Exactly. We will see at 11 a.m., Richie. That's when we're really going to find out because they have people in the courtroom there. Let me refresh the Twitter feed one last time. No new news from the courtroom. All right, let's go back to this. We'll finish watching. We'll continue watching this until then. According to investigators, Boone told them that she and Torres had been drinking wine and playing hide and seek. She claimed she went upstairs and passed out in her bed. They also had been coloring before this and putting puzzles together. It was like a daycare on steroids. She said she woke up hours later to her cell phone ringing multiple times. She then allegedly realized her boyfriend was possibly still inside the suitcase, and when she unzipped it, she found him unresponsive, not breathing. Boone called 911 hours later, and deputies arrived to find Torres dead. Now, everyone, well, you're right, Scissor Man. I see what you're talking about. Let me check you guys over to this. Oh, shit, they're live. Hang on. They just went live. Says he may have taken a plea deal. We can't hear anything, though. His hair's different. You guys, am I crazy? I can't hear anything.
Darrell Brooks Jr., 21 CF 4596, 21 CF 5020. Appearances, please.
Matthew Torbenson and Shelley Grosso appear for the state. Good morning, Your Honor.
Attorney Russell Jones on behalf of Mr. Brooks. Mr. Brooks is present in court, Your Honor, in jury clothing. Good morning.
Good morning, everybody. Hi, Mr. Brooks.
Hello, Your Honor.
We are here. It is the day that our trial was scheduled, but I have plea paperwork, and I understand that the parties have reached an agreement. Mr. Torbenson, do you want to put the state's offer on the record?
Case ending 4596. The state anticipates Mr. Brooks entering a no contest plea to count 3, second-degree recklessly endangering safety as an act of domestic abuse. Based upon that plea to count 3, the remaining charges would be dismissed and read in for consideration at sentencing. As to case ending 5020, the state anticipates Mr. Brooks entering a plea of no contest to count 1, felony intimidation of a victim. Based upon that plea, the state would move the court to dismiss and read in the remaining 2 charges for consideration of sentencing. At the time of sentencing, the state will recommend that the court sentence Mr. Brooks to a substantial term in the Wisconsin State Prison System. We will leave the ultimate interpretation of that to the sound discretion of the court. The defense would be completely free to argue for the appropriate sentence.
It also contemplates the information's not being filed.
Okay. Mr. Torbenson, you talked about count 3 as charged, correct?
Yes.
Okay. All right. Mr. Jones, is that your understanding of the state's offer?
Yes, Your Honor, and I actually did an attachment of an email string between the state and I for clarity of the record.
Okay, I appreciate that. And
I had Mr. Brooks' initial next to the offer section.
great. You're planning or anticipating that it will be a no contest plea. Do you want to make a record as to why that is rather than a guilty plea?
Yes, Your Honor. My client is entering a no contest plea. In those discussions, I indicated that he understands that he'll be found guilty, but he is standing silent as to, he's not contesting the allegations because of potential civil liability, which he may or may not be exposed to with respect to these charges, and therefore we've negotiated a no contest plea. But I will tell you that he understands he'll be found guilty. This is not a maintaining of innocence thing. This has an issue. This is a legal decision based upon potential civil liability.
All right. And the state that was part of your offer, and you are willing to accept a no contest plea for those purposes?
I am understanding that the victim, Ms. Patterson, can still seek restitution in these matters if she so wishes. We are not objecting.
All right. All right. And the court is willing to accept it for the reasons that have been stated on the record. The named victim will have the opportunity to put in a request for restitution that is separate from a civil liability thing. So that will still be a potential that will be part of this. So, Mr. Brooks, it is my understanding that you are planning to enter a guilty plea today to
no contest.
charges. See, I told you I would do it.
I know you did.
It is habit. I apologize. A no contest plea to 2 of these charges that are pending against you. Is that correct?
Yes, Your Honor.
All right. Have you had any drugs or alcohol in the past 24 hours?
No, Your Honor.
Are you on any medications?
No, Your Honor.
Are there any medications you're supposed to be taking that you have not taken?
No, Your Honor.
All right. You've been charged with a number of counts in each of these cases. It's my understanding that you're going to enter a guilty plea to the 2. or sorry, I said, did it again, no contest plea to the 2, and then the other charges will be dismissed and read in. What that means is for the dismissed and read in counts, you will not face any penalty for those, nor will you have a conviction for them. However, when we get to sentencing, the state will make their argument as to the facts of the case, and they can argue the facts that relate to those dismissed and read in charges. And I can take those into consideration when I sentence you on the 2 that you entered the no contest plea to and that you were ultimately found guilty of. Do you understand that?
Yes, Your Honor.
All right. So for the 2 that you are going to enter the no contest plea on, the first is a second-degree recklessly endangering safety with a domestic abuse assessment. That means that it is a Class G felony, and for that you face the potential penalty of a fine of up to $25,000 and imprisonment of not more than 10 years or both. That 10 years is broken down into 2 parts, 5 years initial confinement and 5 years extended supervision as a maximum. Do you understand that's what you're facing?
Yes, Your Honor.
In addition to that, because of the nature of the crime, that this is someone that you have been involved in a domestic relationship with, or either resided with, or have a child with, you would face the domestic abuse assessment for that, which is just an additional $100 penalty that would apply against you, as well as a federal ban on ever possessing a firearm. Do you understand that?
Yes, Your Honor.
All right. And then on the count 1 felony intimidation of a victim, that you're going to enter the no contest plea on in case 21 CF 5020. That is also a Class G felony, potential penalty of a fine of up to $25,000 and imprisonment of not more than 10 years or both, broken into that 5 years initial confinement and 5 years extended supervision piece. Do you understand that?
Yes, Your Honor.
Do you also understand that if you were to be sentenced to prison, you would have to serve in prison each day imposed as initial confinement, because initial confinement time is not reduced by good time or by parole?
Yes, Your Honor.
Do you further understand that when we get to sentencing, I was not part of any negotiations, so I'm not bound by anybody's offer or recommendation. I will listen to what the state has to say, anything that the alleged victim has to say, either in writing or in person or in, I guess, any other form. Anything that your attorney says, anything that you say, and anyone who speaks on your behalf. I will take all of those things into consideration, and then I'll sentence you as I see fit, which could be up to and including the maximum penalty. Do you understand that?
Yes, Your Honor.
Do you also understand that because these charges are felonies, once you are convicted, there's some additional consequences, including the fact that you will never be allowed to possess a firearm at any time in the future. You may not vote in any election until your civil rights are restored. You will have to provide a DNA specimen to the Wisconsin State Crime Lab for DNA testing. And because these are violent felonies as defined under Wisconsin law, you may never possess body armor at any time in the future. Do you understand that?
Yes, Your Honor.
Do you also understand that if you are not a citizen of the United States of America, the plea of guilty or no contest for this offense with which you were charged may result in deportation, the exclusion from admission of this country, or the denial of naturalization under federal law? Do you understand that?
Yes, Your Honor.
Do you further understand that if you enter a no contest plea, you will be giving up all the same rights as if you had pled guilty? And at the end of this, even if you enter a no contest plea, I will find you guilty of these crimes. Do you understand that?
Yes, Your Honor.
All right. So what is your plea then in 21 CF 4596 of second degree recklessly endangering safety with the domestic abuse assessment?
No contest, Your Honor.
All right. And in 21 CF 5020, intimidation, felony intimidation of a victim.
No contest, Your Honor.
All right. Now I have in front of me your plea questionnaire and waiver of rights form. Did you go over that with Mr. Jones and sign off on it today?
Yes, I did, Your Honor.
Do you understand that when you say no contest, rather than asking for a trial, you give up a number of constitutional rights that are guaranteed to you? Those include your right to remain silent and not incriminate yourself, the right to see and cross-examine the state's witnesses, as well as call witnesses on your own behalf and have them come to court to testify for you, the right to actually have a trial, which could be a jury trial where 12 people sit together, listen to the evidence, and then must agree as to each element prior to reaching a decision, or a court trial where the judge listens to the evidence and makes a decision. And finally, the right to make the state prove you guilty by evidence beyond a reasonable doubt that you committed the crimes charged. Do you understand you give up all those rights when you say no contest rather than asking for a trial?
Yes, Your Honor.
Do you also realize you're giving up the right to raise any motions, such as suppression of the evidence, identification of you as the person who committed the crime, suppression of any statement you may have made, or any challenges to the information or the complaint?
Yes, Your Honor.
Do you also realize you're giving up the right to raise certain defenses you might have, such as insanity, self-defense, intoxication, alibi, coercion, and necessity?
Yes, Your Honor.
Did anyone make any threats or promises to get you to enter into these pleas today?
No, Your Honor.
Did you read and understand the criminal complaints that were filed in these cases?
Yes, Your Honor.
And did you discuss with your attorney the elements of these offenses?
Yes, I did, Your Honor.
Do you understand that if we had a trial, the state would have to prove as to the second-degree recklessly endangering safety that on November 2nd, 2021, at 7311 West Capitol Drive, that you endangered the safety of another human being, that you endangered the safety of another by criminally reckless conduct. That criminally reckless conduct means that the conduct created the risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and you were aware that your conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means serious bodily injury, injury which creates a substantial risk of death, or which causes serious permanent disfigurement, or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ, or other serious bodily injury is great bodily harm. Do you understand that's what they would have to prove at trial if we had a trial in this manner?
Yes, Your Honor.
And you understand that by pleading no contest, you are admitting that you believe that the state has adequate evidence upon which they could convict you, and you are opting not to challenge that evidence. Is that correct?
Yes, Your Honor.
All right. As to count 1 in 21 CF 5020, do you understand that's the felony intimidation of a victim, that if we had a trial on that matter, the state would have to prove that between November 5th, 2021 and November 15th of 2021, from 949 North 9th Street, that, what are the initials? EP?
Yes.
EAP, was the victim of a crime, that you prevented, dissuaded, attempted to prevent, or attempted to dissuade EAP from reporting the crime to any law enforcement agency, and that you acted knowingly and maliciously. Do you understand that's what they'd have to prove as to the felony intimidation of a victim?
Yes, Your Honor.
And you understand that by entering that no contest plea, you are admitting that the state has adequate evidence that they could use to convict you of that, and you are opting not to challenge it. Is that correct?
Yes, Your Honor.
Have you had enough time to go over this case with your attorney?
Yes, I have, Your Honor.
Are you satisfied with his representation?
Absolutely, Your Honor.
Do you have any questions, or are you confused about anything we're doing here today?
No, Your Honor.
Are you pleading no contest because, again, you understand the state has adequate evidence upon which they could use to convict you, and you are opting not to challenge that evidence?
Yes, Your Honor.
And are you entering this plea freely and voluntarily?
Yes, Your Honor.
Mr. Jones, have you gone over the plea questionnaire and waiver of rights forms with your client?
I did.
Are you satisfied that your client understands the nature of the charges, the elements, the maximum penalties, and all of the rights that he's giving up by pleading no contest, including the fact that he will be found guilty, and also including any possible motions or defenses?
Yes, Your Honor. And to that end, I also handed Mr. Brooks about 100 and some pages of reports today, just so he would have them, the witness list, the amended information, and there's additional documents I'll be sending to him. Although he has them on digital format, I wanted him to have them in paper format. We went through the no contest discussions. We also had a discussion, not just today in your bullpen, but also, and I'm not getting into the substance of it, but also on Saturday, we were able to have a fruitful conversation. So I think that Mr. Brooks is doing this knowingly and voluntarily.
All right. Are you satisfied that alcohol, medication, or drugs are not affecting your client's ability to understand what he's doing in court today?
I am.
Are you satisfied the plea is being made freely, voluntarily, and intelligently?
I am.
Are you aware of any reason in law why I should not accept this plea?
No.
Does the state consent to the jury waiver?
We do.
All right. The court approves the waiver and finds that the defendant is entering this plea freely, voluntarily, intelligently, and with full understanding of the nature of the charge, the maximum possible penalties, and all of the rights being given up by pleading no contest, and the court accepts that plea. Mr. Jones, may the court use the facts in the criminal complaints to stand as the factual basis?
Yes.
All right. Mr. Brooks, You said that you read and understood the criminal complaints. Are you agreeing that you believe that the state could prove that those facts are true and therefore you are opting not to challenge them with your no contest plea?
Yes, Your Honor.
The court finds that there's a factual basis for the acceptance of your plea, and based on your pleas of no contest, the court now finds you guilty of the offense of second-degree recklessly endangering safety with the domestic abuse assessment and felony intimidation of a victim in the manner and form as charged in the information, and I judge you convicted as of today's date, and I order judgment of conviction to be entered into the record. Is the state moving to dismiss and read in the 21 CF 4596 counts 1, 2, 4, and 5?
Yes, and counts 2 and 3 on 5020.
Okay, you got there before I did. That's fine. All right, those will be dismissed and read in for the purposes of sentencing. It is my understanding that we're setting sentencing off for another date. We will select that date in just a moment. At the time of sentencing, Mr. Brooks, and I am going to keep this. This was, I had this case in the domestic violence court. I came to another assignment, but I kept it because I had done much work on it, and I thought for continuity it was best. I will be transferring to another assignment in August. If we get a date before that date, I am specifically keeping this case. I will see it through. So at the time of sentencing, I am willing to listen to oral statements of counsel as well as anything that you have to say, Mr. Brooks, as well as EAP. If you would like to have a friend or a relative speak on your behalf, I'm more than happy to talk to that person. If there's more than one person who wants to do that, they should put their comments in writing and get them to Mr. Jones so he can electronically file them at least 3 days prior to that sentencing. If there are issues of restitution, that will be determined at sentencing if possible. Is there a request for a pre-sentence investigation?
No.
No,
All right. And is,
I'm not moving for remand. I normally would in a case like this, but given where Mr. Brooks is serving a sentence and my understanding that Mr. Brooks wants to return back to Boscobel, I'm not asking for remand.
right, I agree with that.
Correct.
Generally, I would remand someone given the seriousness of the charges that you just entered into and that what the state's recommendation of substantial prison would be. But given your situation, I don't want you to have to be held in the Milwaukee County Jail rather than returning to the prison setting where you have been housed. So I am not going to remand for that specific reason. I know you will be held. That is the court's goal, that you be held in custody, just not necessarily here. So
Thank you, Your Honor.
you're welcome. All right, so I have some warnings for you. You may not have any firearms as you are now a convicted felon. The maximum possible penalty you face for violation of that is a $25,000 fine and a 10-year period of imprisonment. You cannot vote until your civil rights are restored. You may not possess body armor, and any no contact order remains in place at least until after sentencing. All right, we will select a sentencing date, and I will see you then.
Thank you, Your Honor.
You're welcome.
Parties available August 9th at 9 o'clock.
No. That week I can do any of Monday, Tuesday, or the Wednesday, not the Thursday or Friday.
That week is not good for this court.
Okay. Then the following week is a good week for me, except for Monday.
Okay.
Generally.
August 16th, 9 o'clock.
That'll work.
Works for the state.
Yes.
Next court date will be August 16th at 9 o'clock for sentencing.
Friday, August 16th. Worst you probably did a week yet. I get you.
I want to go.
Wow. They cut the audio feed. I'm sitting here eating my almonds, all going, oh, what in the world is going on? Somebody kept asking about him being strapped to a wheelchair. A lot of people are asking about that. Y'all, they're doing that because I think they're doing that because they have him strapped into it. There were some problems they had with him early on in this case where he wouldn't get out of his cell, and they probably do that so they don't have to worry about him saying anything, and they can get him straight to the jail. No BS. Well, there you have it, folks. Who else's just jaws hit the floor when that happened? I did. I cannot even believe that. Am I muted? Can y'all hear me? So he's not in Gen Pop yet. From what we understand, he's in that max security prison. And the reason he wants to go to that super max prison, Kimmy, is because, welcome in, by the way, girlfriend, is because he's to himself, he's safe. No contest means that he's not. Oh,
right here.
let me cut that feed.
And is that
They're doing that Young Thug case. No contest just means that he's not admitting guilt. There's a catch to this, y'all. Either he's getting something out of this from the standpoint of his appeal, possibly, or it has something to do with him being scared about being in that Milwaukee jail. He may not feel safe there. Because y'all know good and well, he didn't do it for anybody else but himself. Don't even think that he claims to have found Jesus and all that, but we know he's a liar. He uses Jesus as part of his ploy. You saw a black eye? Proud Mama. You make me want to sing some Tina Turner, Proud Mama. Let me, with your name, let's go back to that. Hang on. Let me pull that stream up again. Go to my history. You're talking about when they pulled him out of the courtroom? I'm going to pull that up. Let me share it. We'll do a slow.
For a pre-sentence investigation?
No.
No.
All right.
We'll do a slow play-by-play. Let's see. You were talking about when he did this right here. Which eye do y'all think's black? His right or his left? Let me. No, I don't feel sorry for me. Oh, it is. Is it? Wait, go back. Yep. Y'all, that's got to be a black eye, right? It really looks like a black eye right there, but is it just a shadow? I don't know. I don't know, y'all. Black eye. But see, when he comes out of the shadow, it's not as dark. Wait, let me go back here. Let's go slow mode. It does, doesn't it? Oh, yeah. Ooh, whoever caught that? Who caught that? Who in the chat was the one that caught that? Somebody's paying attention. Notice he doesn't look at the. Oh, there he goes. Get your last little look at the camera, you thug. Maybe that's it, Gene. Maybe he's scared to be in the Milwaukee prison. And that's all I'm saying. That could be it. Something, he's not being protected there like he is over at the other one. If you guys are wondering about where he's at now, this basketball, just all you have to do is go to the playlist And there's a video, and I've got in the title Max Security Prison or something like that. Max Security. So you can watch. We didn't really do anything formal. We were just kind of on a live looking at the prison facility photos, and John Bubba came up and did a little bit of a chat on what he thought about, because he used to be a prison guard, so he was kind of telling us a couple of ins and outs and stuff. But we were kind of pulling. It's one of those places where he's behind a locked door, and it's like he doesn't even have. It's literally it's a door. It's a big steel door. He has like nothing to the outside world. One little baby window on his door, which they can shut if they want to. And they put their food through the tray slot. Yep, that's definitely a black eye, you guys. Well, there you have it. Because, like I said, they never, he's getting his abuse handed back to him. There's no way he's going to do anything for the profit of anyone other than himself. Oh, 555 on the chat. Please make sure you guys hit the like button for me, please. Anything and everything he does is for himself, not for anybody else. So there's no way that he was doing this so poor Erika, or to help his attorney, or to for the sake of the Waukesha victim. No. This was all for Darrell. So we knew there had to be a reason behind it. Could it have helped his appeal some in Waukesha? Quite possibly. It could still show some effect. I don't think it's going to be that much of an effect. That's an attorney question, which y'all go to Southern Law and see what he says about that. Southern Lawyer. See what he puts up about that. He does a lot on Darrell. But I just kept thinking it's the Milwaukee jail, because he laughed and said, oh, hails bells. Let's go back to it. She said, I'm not going to make you stay in the Milwaukee jail. And he goes, oh, thank you. So what I think happened is, before they went on audio, they were explaining that he was probably beat up or something.
The criminal complaints. Are you agreeing that you believe that the state could prove that those facts are true, and therefore you are opting not to challenge them with your holds in the Milwaukee County Jail, rather than returning to the prison setting where you have been housed? So I am not going to remand for that specific reason. I know you will be held. That is the court's goal, that you be held in custody, just not necessarily here. So
Thank you, Your Honor.
You're welcome. All right, so I have some warnings for you. You may not have any firearms, as you are now.
Definitely something happened. I mean, obviously he got a black eye, but apparently he's going to stand up and say, I was hurt. I bet he went to medical and he made a big fuss about it. There was, y'all. Rosie says we're all in shock. I just cannot drink enough coffee. I'm off the rails right now. So we're going to go back to what we say, August the 6th. I wrote it down on my calendar. No, August the 16th at 9 a.m. We will be back. So anybody else have any last minute comments on when they slam me down? He got that black eye when they slammed him down. And maybe his lawyer gave him the black eye. Well, he's not Sarah Boone, but yeah, if I was Sarah Boone's lawyer, I might give her a black eye. His cheeks look swollen also. It's abuse. It's abuse, Your Honor. Does Erika still get to make a victim statement? Okay, so Carol, yeah, I think so. So on August the 16th, when they go in for the sentencing, I'm sure she's going to write a letter or something to the judge prior to that, but she'll probably be able to get up and read it in court. I think she needs to be able to get up and read it in court. I think it's going to be very powerful for her. It's going to help her heal. And so I do hope she gets to do that. And you know what? She may just come on for Zoom for that, something like that. Okay, so the appeal, Sean Malone, is in the natural process. I mean, they're still doing discovery and everything else in that. They've asked for extra time, and Sue Opera even commented that the appeal was in its normal phase. Nothing strange, nothing crazy. They just needed extra time because I mean, the transcripts were so heavy and crazy in that case that I guess it was taking them longer to get them done. And so they automatically granted his appellant attorney more time to look at those and do what he needed to do. He said that he felt like, what did I say when we did that trial? I swear I think Frankie's got a fur ball. Y'all hear him over here breathing funny and hacking? What was it that they said the reason they thought he had a chance? It wasn't subject matter jurisdiction. I forgot what they said it was. Even though there are channels out there who completely demolish Erika's character, it's absolutely insanity and bullying. I know. Isn't that sad? Somebody who's going to beat down a woman who's been beat down her whole life. You going to do that for views? What? Yeah, I don't agree with that either, Melly. I think it's so sad. I hope she gets her last say. Let's hope she gets the last word. And I hope she's not taking his phone calls. She does, like, she's given him so many chances. Oh, he's a complete coward. He's what, 5'3"? Okay, maybe 5'5". 130 pounds? I could take him, and I got a bad knee. Yeah, it has to do with safety. But I do feel like they probably said we can only do this or that for your safety. And you know how that goes when things happen, I guess. John Bubba can speak more on that, but things happen in jail that a lot of people don't know about, I guess. He was not wearing his glasses. Gene, maybe that's what happened to his glasses. They got knocked off when he got hit. She does not talk to him. Are you saying that or are you asking me that? I just heard that she there were rumors that she did, but we don't know. If y'all want to know what's going on with Erika, just go to her channel and give her some love. Watch her channel. Give her some likes. I think she's monetized. She should be. I think she's got over 1,000 viewers. So you can catch up with her on there. You're absolutely right, Terry. There's nothing compared to the black eye that he gave Erika, though. But it was nice to see him have a black eye. Knowing Brooks, he probably drew it on in the bathroom. Kimmy says, well, at least Erika's free. Amen, girlfriend. Teresa says, I'm telling you, I talked to her. What are you saying, Teresa? I missed what you said, honey. Hang on. She doesn't talk to him. Okay. Well, good. Good. And I am glad because if the sooner that this gets put down, I mean, as much as we love the entertainment of it all, as soon as this gets put to rest, then all the Waukesha victims can truly heal. Zephyr says she did make a recent video and that she has not talked to him. Team Erika, you go, Jean. Yeah, we team Erika on this channel. I just hope I hope she's good. I hope she's gonna bounce back and all that. And if she's watching this by any chance, which I don't know, maybe she is, girl, if you ever want to come on my channel, I will not do you wrong. I got your back from one female to another. I've never been in that situation, but I can only imagine since the age of 15, this man has been grooming her and what she has been through. And anybody that wants to go off on women about not being, why would you put up with that? Why didn't you get out? You had so many chances. You don't know. You weren't there. You're not in her position. There's a lot of different links in that chain. And possibly some of us may never know. I hope she has somebody to talk to, though. I hope maybe she's getting, she has a therapist that she can talk to go through it and just kind of, sometimes just getting it out, saying it out loud helps. just be careful saying a lot of stuff on YouTube, because I feel like people get on there and just are jerks. I was watching, I told y'all the other day I like to watch Dateline and 48 Hours on YouTube. I was watching that the other day, and it was a case that was sad. It was a really sad case. And for some reason, the chat had popped up. And I usually don't read the chat and stuff like that. The only time I read the chat is when I'm in y'all's channel, when I'm in my channel listening to y'all. And I just got so mad because they were saying so many rude things and making fun of the people the family victims that were like, did the commentary and were talking on the show. And I just think this is what they do with this stuff. People just take advantage. I mean, not that they take advantage. It's just like, people are idiots. What do you get out of sitting here making fun of somebody who's been through something? Vincenny, where you been? He pled out, dude. Well, he took a no contest. Hey, Chris. Sherry says, as a survivor of DV for 10 years, I can tell you it's not easy to leave your abuser. I can't imagine. What was I watching the other night? I'm trying to think of what I was watching. Somebody was trying to get away from somebody, and it was just a cycle. It's like they were damned if they do and damned if they don't. And there still are not enough laws for people that are abused. There's still too many chances where, people are being stalked and all the things that have to be proven in order to get a restraining order. And then what does a restraining order really do? A restraining order doesn't put a metal shield around that person. It just says that if you get caught being that person, you're going to get put in jail, Well, you guys, I need to go take care of my little girl. That's my sister's baby who they're having to put down today. It's a dog. She's a dog, but she's their baby. She's their little princess. Yeah, very well said, Kauai. She can close this chapter and move on. And hopefully she realizes how worthy she is of a good man that's going to treat her right, not talk down to her, and not put a hand on her. There are so many men out there that will not put a hand on you, girlfriend. If you are watching, please know that. Or, you know what? You don't have to be with a man. You can be by yourself. You're a strong enough woman. You got a good head on your shoulders. And what else? She's doing great in her medical field. She doesn't need a man in her life. So that's my last words for the day. I'm so glad that I saw a black eye on him. I'm sorry. That's just, it could be mean, but when it's Darrell, it's not mean. You know what I mean? It's not mean. That's not mean that I said that, right? All right, you guys. Well, thanks for watching. I really appreciate you. Please don't forget to hit that like and subscribe button on your way out so you'll be notified the next time I upload a video. And we'll continue to follow this case. I'll definitely be back on August the 16th at 9 a.m. Central Standard Time. Same bat channel, same bat time. See you then. Y'all be good.